Hello everyone, today's recording date is June 24th, 2024. This is Michele Tittler from the political organization in Canada, Endrace Law. This is my political partner, Gerry Gagnon.
Hello again.
And today's episode 6 is from a feature story on endracebasedlaw.ca called What Happened to Legal Equality? The Gladue Court Ruling. All the feature stories, all the longer, more philosophical stories with the longer research are on endracebasedlaw.ca, as well as the videos that we are creating. If you want the daily news stories, because there are so many, you go to endracebasedlaw.ca, but they're both hooked up to each other. Lots and lots of stories in this particular subject. Today's What Happened to Legal Equality from Gerry.
Okay, so when we started this project, we were constantly asked, what race laws? Canada doesn't have race laws. And we felt like we had found so many examples of it that we were stunned at how unaware Canadians are of the discrimination built into not just our courts and legal system, but the Constitution itself. Now, probably the most glaringly obvious one is referenced by the name of a court case. Gladue was the name of an Aboriginal case that went all the way to the Supreme Court. And it resulted in a ruling from the Supreme Court that special consideration had to be taken when Aboriginals were being sentenced in court. Parliament complied with an amendment to the criminal code that then made that law. So rather than my words here, I'm going to read from a couple different articles that are in this post that will explain this to you. In attempting to cope with the high proportion of Aboriginals in Canadian prisons, Parliament and our judicial leadership have unfortunately resorted to differential treatment based on race and heritage. It's called Gladue, after the name of a Supreme Court case. The court, instead of doing its duty and tossing out the discriminatory legislation, sided with Aboriginal exceptionalism and extended segregation into court sentencing. Criminal Code Section 718.2, subsection E. All available sanctions other than imprisonment that are reasonable in the circumstances should be considered for all offenders, with particular attention to the circumstances of Aboriginal offenders. Now, this has created a whole new industry we'll talk about a little later in this podcast. This discriminatory clause is what the Supreme Court based its discriminatory Gladue ruling on. However, it conflicts directly with Section 718.2, subsection B, 3 lines above it in the Criminal Code text. B, a sentence should be similar to sentences imposed on similar offenders for similar offenses committed in similar circumstances. There's no exceptions to subsection B here. It's very clear and explicit that we're supposed to receive, as individuals, equal treatment as individuals under the law when we're in court. The section E that was added contradicts this. It subverts it. And how the Supreme Court could justify both of those being real law, well, we'll leave that for you to decide. Not only does the law make it mandatory to consider an Aboriginal person's circumstances, their lifetime, their race, defense counsel has a responsibility to bring those circumstances to the attention of the court whenever jail is a possibility. If defense counsel fails, the job falls to the Crown, the prosecution. And if both defense and Crown fail, then the judge must make his or her own inquiries of the person before the court. This has to happen if an Aboriginal is being sentenced in court. And only an Aboriginal. It does not apply to anyone else.
Does it say how much they have to be Aboriginal?
Nowhere. And this is, of course, a whole other topic.
They need a blood test.
So, according to Canadian law, judges must pay particular attention to the circumstances of Aboriginal offenders in order to reduce the overrepresentation of Aboriginals in the justice system. They must do so even if the Aboriginal offenders' lawyers do not raise the issue of their client's race at trial. They must also make allowance for offender status in regard to whether offenders live on or off a reserve. If this information is new to you, don't worry. The issue of unequal justice in favor of Aboriginals seldom comes to the fore because, to be frank, most violent crime committed by Aboriginals is committed against other Aboriginals. That likely explains the justifiable public outrage at ultra-light sentences. For instance, here's an older example, but a really strong one. Richard Smoke received a light sentence for a vicious beating he laid on a home builder during the violent and illegal occupation of a residential subdivision near Caledonia, Ontario. Sam Galtieri and 3 other construction workers were building 4 homes at the Sterling South subdivision. One morning in mid-September, Mr. Galtieri and his men arrived at one of their projects and saw silhouettes moving around inside. Mr. Galtieri went in to investigate, only to find 3 Aboriginals camped out inside. He confronted the trio. His men followed only moments later, yet by the time they entered the framed-in home, Smoke had already badly injured Mr. Galtieri and was standing over his limp and battered form with the 2x4 he had swung, using both hands at the contractor's head and body. Smoke's underage accomplices had fled. Several of Mr. Galtieri's bones had been broken, including some in his face and head. He sustained permanent brain damage and still has trouble reading, speaking, and walking.
He wasn't the right race.
For this vicious attack, which Ontario Superior Court Judge Alan Whitten described as, quote, just a notch below culpable homicide, unquote, Smoke was given a sentence of less than 2 years. This special treatment isn't unusual for Aboriginal offenders, but it shouldn't stand either. The Gladue decision, which established the practice of preferential treatment for Aboriginal offenders, came at the end of a period of particularly irrational sentimentality from the Supreme Court in regard to Aboriginal issues. Over 6 years, ending with Gladue, the court manufactured out of thin air several precedents that favor Aboriginals. The justices decided that First Nations oral histories should have the same force when determining land claims as land title records, written treaties, and scholarly research, which undermines a fundamental principle in Western law. They also decided that Aboriginals could hunt and fish with impunity, in or out of season, indifferent to most conservation regulations, because that was their traditional way of life. In one especially appalling decision, the 1999 Marshall case from Nova Scotia, the court so badly misinterpreted the history of early maritime treaties that it was forced to issue a formal correction of its own ruling, but decided still to stick with its initial decision permitting Aboriginals to fish commercially out of season, even though it got the evidence upside down and backwards. Aboriginals do not need special treatment in court, nor has the special treatment they have received over the past 14 years done much to reduce the rates of Aboriginal crime or violence. Moreover, while Aboriginals may be overrepresented in prison relative to their share of the population, 21% of prisoners versus 4% of the population, they are not overrepresented relative to their involvement in crimes. About 1 in 5 crimes in which the race of the subject is identified is committed by an Aboriginal, just as about 1 in 5 prisoners are Aboriginal. The kind of preferential treatment Richard Smoke benefited from only encourages would-be First Nations offenders to commit crimes because they know the consequences will likely be light. At the same time, it is an insult to Sam Galtieri, victimized once by a man with a 2x4 and again by our court system that denied him justice. Now that's from an article that Lauren Gunter wrote for the National Post, and I'd like to thank him not only for that, but many other pieces he's penned that show the kind of objectivity and sanity and true progressive values that are sadly lacking in this whole discussion. And I think, although there's far more to this post that I was going to read another excerpt, I think I'm just going to let it stand at that. If this interests you, there's far more material along with this post. There are links to the criminal code laws I referred to, links to the ruling by the Supreme Court, and at the bottom, several other posts we've done where we've shown other violent offenders, extremely violent offenders, and the lighter sentencing they've received because of the so-called Gladue provisions. So when we speak of ending race-based law, this is the kind of thing we're talking about. And it is real in Canada. It's happening daily in Canada. It's a billion-dollar industry now underlines this, and that's going to make it more difficult to end this segregationist nonsense. But all the more reason we have to. So thank you again.
Well, I want to say
Michele
something.
wrap it up. Yes.
I want to say that this is what's happening in the United States too. They're using the blacks. Like, this is the United Nations using the natives in Canada, using the Aboriginals in Australia, using the Aboriginals in New Zealand, using the blacks in the United States. They're trying to do a number of things: destroy Canadian sovereignty and other countries' sovereignty, create race wars, and they're just using one race against the other to pit them against. I mean, what they ultimately want to do, that's what the land back is all about. They really want to use the natives to take all the land, and well, of course the natives aren't going to get it, and the United Nations are going to take it. So it's really just a land grab, and it's just a destruction of all our sovereignties. And they've got all of these psyops going on in all of these countries, but they've infiltrated us a long time ago, like 35 years ago, and this is where we are now. And now natives are just like open season for them to do anything they want, and what they really need is to talk about their fetal alcohol syndrome problem, because these kids are born with fetal alcohol syndrome and violence and sexual perversion. This goes along with the whole thing, and then it just adds to the whole criminal thing, and then they just get off again. Like, it's just, no one is actually helping them. And that's what bothers me the most, is no one is actually helping them. Like, if I were a chief, I'd be saying we need to get sober, first and foremost.
Well, one of the ironies here, of course, is in the original treaties, and remember, we're supposed to honor the treaties,
They
treaties.
always say that, and they never honor the treaties, ever.
And in the original treaties, certainly the numbered treaties, there was a specific provision asked for by the chiefs, but both sides agreed,
Yep.
that prevented alcohol on the reserves.
Yep.
In 1960, our progressive Supreme Court of Canada ruled that unconstitutional because it discriminates against reserve Aboriginals where alcohol is
So
concerned.
it's okay, you can't have discrimination when it comes to alcohol in the reserve, but you can have discrimination with all the rest of this stuff.
And the irony is, at the time, the chiefs were opposed to that Supreme Court ruling. They didn't argue to have it removed.
Yeah.
It was what we refer to as do-gooder racists.
Yep.
People they think they're doing good. This started at the beginning of this country, where people thought they were doing the right thing, but they were so self-righteous about it that they did the wrong thing.
Well, because so many of the chiefs saw that alcohol, they were allergic to it, and they knew it was their downfall. Those chiefs who signed those treaties knew that alcohol was their downfall.
And so what happened to honoring the treaties in that case?
Yeah.
Like, it's obviously
They get us coming and going.
a lawyer game.
Yeah,
that
they
can
get us
be
coming and going.
flip-flopped.
They only honor the treaties when it benefits them. Otherwise, and they just tell you, shut up, you racist colonialist, go home, settler. So then I always call them Siberian settlers, because they're from Siberia. That drives them crazy. They're like, no, we're from Turtle Island. We literally sprung here from like the beginning of Earth. That's what they say. It's like, no, I'm sorry, you're settlers too, and you roamed around too. You're wanderers too. You raped and pillaged each other too. You fought each other too. You stole each other's land.
We'll be doing a future podcast on
don't bullshit us.
The issue of the Bering Strait crossings, etc.
Yeah.
And the DNA.
Yeah, that's a really good one too, because I even went and looked up, we'll close off with this. If you go look up the Siberian kids, and then you look up the really, there's not that many Aboriginals that have their full DNA anymore, but they look like the Siberian kids. They just do. Okay? We've been migrating around Earth for a long time, and this whole land is big enough for all of us. This land is your land, this land is my land. Okay, we're going to end now. Say goodbye, Gerry.
Till next time.